Thank you for standing by. You've been joined by your leader now. So your line is open.
And I'm the speaking.
Go ahead.
I'm the speaking line?
Yes, you are.
Okay, thank you.
You're welcome.
The last example would be Deborah Hicks. She's a business owner in Hobbs who also supports Holtec coming to our community. And we're here today to show our support. The Holtec CISF is welcome in our county, and we look forward to having Holtec provide jobs and tax revenue as well as other benefits that it will create. We're an energy-based economy. We support oil and gas, nuclear energy in Lee County and Eddy County. Thank you for your time.
Thank you, Mr. Sepp. I know tomorrow we'll hear from the city of Carlsbad. Did we have someone from the city of Hobbs who wants to speak separately? We don't. Okay. So just tomorrow we'll make time for the city of Carlsbad, which gets us back to the hearing petitions. And I think the next up in order would be Alliance for Environmental Strategies. Is that Ms. Simmons? Oh, absolutely. Yeah, I'll repeat again. If any of the speakers want water, that's why it's out there. We don't have tables for everybody here, but we're trying to be as accommodating as we can.
Welcome to New Mexico.
Thank you.
Good afternoon. I have, on behalf of the Alliance for Environmental Strategies, 2 points I'd like to make this afternoon. The first is, I'm having a hard time with the microphone, I think, because I'm too short. Is that better? Okay, thank you. I'll try to look up. I was asked by AFES to address the problem of dumping of nuclear and other waste in Lee and Eddy County many months ago, because I've done some work in the area of environmental justice. I'm primarily a civil rights attorney. They specifically were interested in the particular effect on the minority population in Lee and Eddy County, which is perceived, at least, as in effect a targeting of the border area of the United States for multiple dump sites for nuclear waste and other types of waste. The sort of the traditional environmental justice point that it turns out so very often that these type of sites end up in low-income minority communities in the South and on the border, and very much in New Mexico. I looked at the Holtec application as my preliminary step, and what surprised me was that there really wasn't any study that addressed in any kind of scoping process what the potential discriminatory effects may be. Instead, there was an adoption of a prior report done by ELEA, I think they call themselves, but nothing else, nothing specific as to this community right now. People were not really invited to participate in any kind of explanation of how this might affect them, and there was no real demographic study other than the adoption of what ELEA had done before. And one, for example, particular point that AFES would want to raise is what's the demographic comparison we want to do. If you compare, for example, I think this is a helpful example, if people contended that the current administration is biased against South Americans and Mexicans, and and I'm not saying that's true or false, but let's just say that's the argument, that they're biased against the people crossing the border to the south because of a problem with people from those communities, from Mexico. A demographic study that said, well, look, If you compare the people that are crossing to the people living right on that border in the Segundo Barrio in El Paso, we're not discriminating. We treat those two groups just alike, so we don't see any discrimination. But that's really not the point, is it? The point you'd have to do is compare to the Canadian border and say, oh, well, people on the southern border are treated very differently than people on the northern border, so let's see why that is. And maybe there's an explanation. But that's what I'm saying in terms of demographics. If you compare Lee and Eddy County to the rest of New Mexico, you'll probably find similar numbers of minority population. Because Albuquerque has a big minority population. Northern New Mexico has a bigger minority population than Anglo in some counties. But that's not the comparative piece of this that needs to be done. What we're saying in our argument, and again, I know that's for a later date to try to argue this on the merits, but just in terms of standing, what I would say is that the comparative group is the rest of the country. So what's happening on the border that we think that these communities are targeted for the dumping of waste, we say that the comparative demographic is the rest of the country. Okay, that gets me back to standing. Who has standing to raise that claim? And my issue is that was never even addressed as to what the proper demographic was. It was just an adoption. There was no consideration given to whether the minority community in Lee and Eddy County would have more difficulty with a drop in property values because of the perception in New Mexico that these areas are dumping grounds for waste so that people aren't moving in, for example. So the property values do go down. That was a concern of one of the members of AFES. There wasn't consideration to be given to that. I think we're entitled to raise that claim as a matter of law. This application is deficient in terms of the work that was done to look at these issues. And I believe that the standing issue is traditional standing. The NRC is not supposed to have a more narrow definition of standing. If anything, it should have a broader definition of standing than is in a judicial forum. And in a judicial forum, if I'm being discriminated against by the dumping of waste in my community, I don't have to say that it came within 2 miles of me. I can say the effect on this entire community is that it's lowering the property values, lowering our sense of being a community, lowering our self-esteem, affecting our children, that they feel that they're being dumped on, that we're a waste plan, a landfill, rather than a community. All of that, whether you believe me on the merits or not, because this isn't the point to determine merit, all of that, anybody in that community should be allowed to raise that instead of saying that you have to be next to the dump, because those are apples and oranges. The issue of radiological exposure goes to whether I'm going to be injured if there's an accident. Well, that's not our claim. Our claim is that there is a deficient application in terms of their environmental justice portion of their application. And if you say otherwise, respectfully, I think you end up with a situation where environmental justice just doesn't count. That's not something that has to be addressed. All you have to address is whether this is safe or not. And then you're done. If that's the rule, then it should be clear. There should be a holding that it's not a standing issue. It's on the merits. Nope, environmental justice is not an issue that has to be addressed in an environmental impact statement, period. All we're going to look at is whether the casks might leak or they might not leak, whether this might explode or that might explode. That's obviously critically important, but there are other people that are presenting those arguments on behalf of particular groups today. We are presenting primarily the argument about environmental justice. And so I think we have met the requirements for standing on that. Now, we would also like to participate and ask questions, obviously, about the safety of this proposal. I think we meet that because of the proximity of, well, because the there are members of AFES that travel on the roads that might be exposed to the possibility of leaking casks along the highways and byways in ELEA and Eddy County. So that's my second point. That's all I had to present, unless there are questions.
Thank you, Ms. Simmons. I believe Judge Arnold will begin our questions for you.
Your contention 1 and contention 2, correct me if I'm wrong, they're basically environmental justice contentions of some sort or another?
I have two, I don't know my numbers, but the first one is as a matter of law, and I believe the second one is that we're relying on Dr. Gomez to talk about environmental racism. So, yes. Okay.
I understand, how one could consider the executive order a requirement for the NRC to do environmental justice work. The commission put out a policy statement on environmental justice and say, yes, this is a part of our environmental impact statement, but I'm looking for where is the legal requirement for an applicant to address environmental justice?
Well, I think there are several things. One, there's the Louisiana Services case that talks about that could be an issue. There is the policy state. There's President Clinton's policy statement that has to be considered in anything that is done.
A presidential policy statement applies to federal agencies, the NRC, but an applicant is a private entity. So why does that apply to them?
I see your point. Well, if they don't present that in an application, I don't see how the NRC can rule that the NRC is complying with President Clinton's executive order if there hasn't been any evidence presented or anything in the application to address that.
Okay, so it's a matter of logic rather than being able to identify a specific rule, regulation, or law that says it.
That I know of, and I would appreciate the opportunity to supplement, because frankly that's a question that I had not considered, whether there's specifically a CFR regulation that says that the applicant specifically has to present it in their application. I think because of the natural logic of if the NRC has to consider it, somebody has to present it, and it should be part of the applicant's burden.
Okay, that's all I have on those contentions. Your third contention, there is no factual support for Holtec's primary site selection criterion, which is community support. Once again, can you point to any rule that says they have to provide specific support for statements of that sort?
No, I can't, and I don't think there is in that case. My point in presenting that, and it may have become moot depending on what a Holtec has to say, but my point in presenting that is that their application in terms of the section that they did on environmental justice in their environmental impact statement was, we were invited in by local leaders, so there must not be any problem. And they did a study that basically studied their own counties as opposed to any demographic comparative study that I would see as valid. And that was sufficient. So once we're invited in by local community leaders, we're done with any environmental justice analysis. I said that's not sufficient. You need to do more. You need to do your own study, and it needs to be much more specific than what ELEA did. Their response was, well, this is irrelevant. It doesn't matter whether we're invited in by the local community, so you can't challenge whether we were or we weren't. And then in my reply, I said, okay, if it's irrelevant, then you have nothing in your environmental impact statement about environmental justice, because pretty much you had hung your entire hat on being invited into the community by local leaders. So that contention may go away.
Okay. Do you have any support that their statement of community support is in fact incorrect, wrong?
I don't have anything to suggest that these gentlemen were saying anything other than what they see as absolutely the truth, that their constituents, as they perceive them, support this project coming in to Lee and Eddy County. My issue is, in accordance with what Dr. Gomez said in her report, which I attached to the petition, that when you are dealing with folks that are low-income minority community, the idea that local community leaders speak for Rose Gardner, for example, isn't a definitive decision as to whether low-income and minority communities are definitely swept up into the view that I'm the local community leader and I speak for everyone. I think I can't speak for them, but I think they would probably concede the point that the less income you have and the more marginalized you feel, the less likely you are to come to a town hall and challenge the larger group and say, you know what, I don't want this, because I already feel like I'm being dumped on and I don't want more on it. It's not going to help me in my community as a subset of what goes on in Lee and Eddy County. So I think local leaders and local businessmen and people that have an economic interest in this fully support this, and that's their right. But they don't speak for the members of AFES or for the rest of the low-income minority population without specific evidence. And this gets back to my point of the environmental impact statement. You have to go into those communities. I can't be my own expert, and I get that, but anecdotally, I have worked in communities like this on the border for more than 30 years. And you don't just hold a meeting. When we would hold meetings, we would talk to ourselves. We wouldn't get all this just by saying, here we come, you come tell us. We had to go to where folks were and ask them, what do you need, what do you want? And that's what didn't happen here.
Thank you. I have no more questions.
Thank you. Just sort of three areas of inquiry. First, the executive order, President Clinton's executive order on environmental justice. It may seem a little strange, but the Nuclear Regulatory Commission does not report to the President of the United States, and the President's executive orders do not apply. We are an independent agency. The President appoints the members but does not supervise them, which is a little odd. We're part of the executive branch, but that is the structure. Turns out, doesn't matter, because the Commission voluntarily determined that the agency would follow the principles of the executive order. Now, as I understand the point that Judge Arnold is raising, is that an environmental impact statement is not something that is the responsibility of a private party. It's the responsibility of the government, in this case, the NRC. And what applicants must do is not comply with NEPA, because they aren't the government, but what applicants must do is comply with the regulations that the NRC has promulgated to facilitate preparing an EIS. In other words, the regulations require applicants to have an environmental report, which can become the basis for much of the NRC staff's environmental impact statement. So I have a question for the staff. Do we have a microphone for the staff? And my question is Judge Arnold's question well-founded? Is there a regulation, I guess it'd be in Part 51, that requires applicants for a consolidated interim storage facility to address environmental justice in their environmental report?
Your Honor, Sarah Kirkwood for the NRC staff. We said it.
And just for the record, that's Ms. Silkwood. Ms. Silkwood.
Kirkwood.
Silkwood.
Sorry, Sarah.
What am I thinking? Kirkwood.
Sarah Kirkwood. Silkwood.
Kirkwood. Sorry, my apologies.
For the NRC staff. I'm not sure that there would be a specific requirement in Part 51, but the NRC staff guidance, which is cited in our answer. Okay. Give it a test citation. NRC 1748, Appendix C lays out the categories of information that we expect to see in an environmental report's environmental justice analysis. And I would say that anything that the staff is expected to have in the EIS for purpose of contention and admissibility should be in the ER.
But that is a new reg, correct? Yes. That is guidance, that is not a regulation of the NRC.
That is true.
Oh, could I ask one? Let me quote a sentence out of the introduction to that document. Applicants and licensees are encouraged, but not required, to use Chapter 6 when preparing environmental reports for submissions to the NRC. Does that make it sound like a requirement?
Following our guidance is not a requirement. So we would not deny an application for lack of complying with that document. However, for purpose of contention and admissibility, if it's something that we think needs to be in the EIS, I would posit that it would be potentially an admissible contention. I don't think that's the scenario here.
Admissible or in?
Admissible.
Could I respectfully ask a question?
Yes.
Maybe of Mr. Arnold, and Mr. Ryerson as well. If the NRC is then required to consider environmental justice in an environmental impact statement, how does the NRC go about doing that if it doesn't require the applicant to do it? So, for example, if I'm denied because, it doesn't have to be in the application, that's the current hypothetical or possible position, whatever, and then you're supposed to decide, respectfully again, whether this is going to affect the environment in a way that it should be denied. Do you have to do the work to go out there, or do you deny the application because it's not clear what the environmental impact would be? I mean, it seems there's a bit of, with all due respect, and Mr. Ryerson will remember this from law school days, angels dancing on the head of a pin, to my mind, because if it's required that there be an environmental impact statement that includes environmental justice, and the NRC guidance provides that should address environmental justice, you are correct, Mr. Arnold, that it may isn't shall, but I don't see any way around it.
Yeah. Mr. Silver, yes. You want to
The ultimate obligation is on the NRC staff in this case. If applicants did not include the information, we did include the information, we did follow the guidance, but if we had not included the information, the ultimate obligation to prepare the environmental impact statement rests with the NRC staff. They would go out and develop the information. They would include that information in the environmental impact statement, which is required by their regulations, and the fact that they chose voluntarily to follow the executive order.
Okay, I think we're clear on the point that, in fact, whoops. You okay, Mr.?
Yes. I was listening too hard to the fight behind me.
Here's where I think we are. There's no question. You may say it's inadequate, but the applicant believes that it did submit environmental justice information as part of its environmental report. The staff says that if they didn't, because of the new reg, not a regulation, but because of the staff guidance, they would have agreed that a proper challenge would have been admissible. So the question is, I think, whether your challenge is to what they've submitted is adequate. So I think Judge Arnold has raised a very interesting point that there's not a regulation that requires it. But in fact, I think we're past that to where we started, which was the adequacy of what they've submitted, what the applicant has submitted. Let me move on. I have two other areas. Ms. Simmons, you are absolutely correct that in the federal courts, standing has a constitutional dimension. There is a case or controversy requirement in the Constitution for the federal courts that does not apply to the NRC. Nonetheless, Once again, the Commission has declared a policy that it would generally follow current standards of standing that is applied in the federal courts as a matter of the Commission's discretion as an agency. And they've indicated, and this is all in your pleadings, I'm saying more than I need to, but they've indicated there's different ways to satisfy that. For power reactors, there's kind of an arbitrary judgment that anybody who lives within 50 miles has standing. For groups, if they can show that a member has standing independently, either traditionally or through the presumption, and the interests of the group are aligned with what's at stake, there's such a thing as representative standing. So that's what we're really talking about here. And this board tends to be guided somewhat by what the Commission does. The Commission has found, I believe, standing, the Commission or other boards have found standing in the case of interim storage facilities at a distance of 17 miles, I believe. Your closest member is 37 miles, is that correct?
That's correct.
Okay, and I think if you take the District of Columbia Circuit in the NEI case, which dealt with Yucca Mountain, I think found 18 miles to be sufficient, a tad more distant than the Commission has. But given that these cases are at 17 or 18 miles and your closest resident is at 37 miles, are there any cases that we are missing that show the Commission accepting, or another board, accepting a standing based upon proximity that is closer to your 37 miles?
That I know of,
yes.
Mr. Ryerson, no. But let me also take exception to the premise that the shorthand, the handy shorthand, admittedly so, that there's a certain proximity and you get standing, a certain proximity and maybe you don't. If your problem is with the radiological exposure, is not the point that's being made here. So that there are cases that say that if I am denied a procedural right, which I would assert that a person who is a minority, member of a minority, living in the community that is within, there's a point at which the rubber band breaks. If I'm in New Jersey, I can't complain about the discriminatory impact of what happens in Hobbs. But if I live in the community of Hobbs, if I live in the community of Lee County, and the cumulative impact of dumping on the border communities is hurting me, and I think that that would come out in an environmental impact statement that is well done with an environmental justice aspect. And we've gone through whether that's the applicant's responsibility de facto or whether it's not. But I think I have standing to challenge that issue as not being sufficiently addressed in the application, whether I'm close to the radiological exposure or not, because that's apples and oranges. That's not the point I'm trying to make. So to me, it's like saying that if I am, Hatch, New Mexico has sundown laws, used to, before legal aid got involved, where if you were a Mexican in downtown Hatch, you were in trouble. They passed a law saying you can't have double-wide trailer and live in a double-wide trailer in Hatch, and at the city commission said, this will get rid of those rats, meaning the Mexicans. Now, if I don't have a double-wide trailer and I don't go downtown in Hatch, I'm not close to either of those, but I'll tell you, if I'm a Mexican-American, I can challenge that because I'm not specifically challenging the fact that I can't have a double-wide. I'm challenging that you can't pass laws targeting me as a Mexican-American, and okay, we're off to the races to make my argument on the merits, but I definitely have standing to make that challenge. Now, I take your point, Mr. Ryerson, that that's from judicial cases, but there are also NRC cases saying that, for example, a deficient environmental impact statement is a basis for standing by the group that's challenging the insufficiency of the environmental impact statement per se. So I think it's interpreted broader than you are suggesting because of the nature of the claim we're making. Second, and this is more of the traditional approach before the NRC, my clients do travel on these roads, and there is an admission in the application that some of these casts may leak, and they'll be just sent right back if they're leaking, and that's not enough assurance for my clients. So they have standing on that basis. And let's see, one of my, here, I'm going to read this note. One of my AFES clients, Lorraine Villegas, drives for work within 1/2 mile of the site multiple times daily. That's a fact. That's in the affidavit, so I would add that. But again, I don't think that's the be-all, end-all. I think we have enough because of proximity. The traditional analysis NRC applies because folks travel on these roads and also travel close to the site itself based on the very traditional analysis NRC applies. But I also think that it's way too constricted to say that if you are alleging that you have been discriminated against by the multiple instances of dumping on the border, just very traditional, the definition of a violation of environmental justice principles, if that's my contention and I live in that community, that's sufficient for standing.
All right, I think we understand your position on it. I have just, I think, one more question, at least at this point. We've talked, I think, mostly about your contentions 1 and 2. Contention 3, if I understand it, seems to require us to find that community support would be a relevant issue under the National Environmental Policy Act. And am I correct that that's what you're saying, in effect?
That's what I just responded to from the question from Judge Arnold, which is that the environmental impact statement that Holtec submitted when it was addressing environmental justice focused on the support of local leaders. And to my mind, that means that raises the question whether there is truly support in the community for this, as in if everybody's happy that this is coming, then how is that discriminatory? And that was their position, to my mind, in their application. That was their environmental justice rallying cry. So my response was, well, but that group that purports to represent the entire community wasn't open to all. Now, if they're withdrawing that, which in their response they appeared to be saying that community support is not a relevant consideration. That's not what we hang our hats on. If that's so, then my response to their environmental impact statement is moot because they're withdrawing even that support and saying, okay, we're just going to rely on the study that ELEA did, not on the fact that ELEA is all for us. I do find it, I must say, respectfully to the gentleman, respectfully to the NRC, I find it very ironic that they're allowed to stand up and say how great this is going to be when it doesn't sound to me like they meet the proximity test, but yet their views are interesting. My clients are members of this community that feel excluded from the process because of their position as minority low-income folks, and yet maybe they're going to be denied standing. I think they have the same sort of interest as the local community leaders do in speaking to this issue, because, man, we're the folks, we're the New Mexicans. They're the New Mexicans, so I get why they get to speak, but we're the New Mexicans, too.
Thank you. Judge DeForros, did you have questions? No.
Thank you for your time.
No more questions. Okay, thank you. All right.
Would it be possible to exercise your discretion under 10 CFR 2.315 to allow some portion of time for the community to orally at least address some of these issues?
I don't want to seem curt, but no. We are not permitted to take evidence in those types of statements. Some boards do that, usually closer to an evidentiary hearing. I think it's very rare to ever do that at the time of contention admissibility, which is a legal issue concerning the adequacy of these particular pleadings. So we have petitions that have been filed by the local governments. They are unopposed. As a courtesy, we are allowing them an opportunity to speak. But the general public, this is not an opportunity. There conceivably would be another opportunity. I'll tell you personally, I'm not a big fan of those because I think they mislead the public, because we can't take what people say as evidence if we're close to a hearing. We can't respond to what they say. And frankly, often the issues at that point are very different from what's on the minds of most members of the public. So in any event, at this point, unfortunately, we will not be doing that. But thank you for checking with us. I believe Mr. Lodge? Yes. And you are representing? Representing the joint petitioners, the rainmakers, all 7.
Before I get started, I would like to indicate to the panel that it is possible, depending on the questions that I'm asked, I may be consulting my kitchen cabinet. Several of my clients or client affiliates, and I respectfully request the board's indulgence. I understand the complexities. I understand enough that this is a complex proceeding.
As long as you are speaking to us and not your client, that's fine. Thank you.
That's why they call us mouthpieces. Thank you. May it please the licensing panel and the council, I'm here on behalf of the what I informally consider to be the transportation interveners and public citizen, for the precise reason that this is a national policy determination. It's the implementation of a national policy that hasn't actually been fully hammered out or discussed in a meaningful way for quite a long time, but that there are gaping problems with the Holtec application as it has been put to the NRC. In our view, some of the gaping problems are that there is literally no addressing within the context of the application of the fact that there may not be a mere 10,000 shipments at 500 per year for 20 years, but there may be as many as 30, 50,000, possibly even 80,000 shipments of smaller uniform canisters from the reactor sites. That particular situation stems from a 2008 DOE policy pronouncement relative to the Yucca Mountain Repository. The policy pronouncement essentially is that wherever the repository may be, that ultimately it will be in the interest of the management of the waste and the public health and safety for there to be a uniform standard applied to the canisters that are put forever in the ground for storage. That hasn't been addressed here at all in the application papers that I've read. It implies another aspect that has not been adequately addressed, but which is sort of covered in the application papers. That is the presence or non-presence during the operating life of the Holtec facility of a dry storage system or something akin to it. And by that I'm talking about a complicated technological system that protects the workers and minimizes radiation leakage or exposure, that allows the unloading of canisters for the purposes, among other things, of either remediating arriving canisters that are damaged, remediating canisters on site that, as time passes, become damaged or show signs of contamination, or transferring spent nuclear fuel delivered to the site from transport canisters that are not of that smaller uniform size contemplated by the DOE policy. Another problem, which we believe is very distinctly related to these transportation issues I've been talking about, is that we're talking about millions of miles, millions of road miles, millions of water miles, and millions of highway miles of travel for the thousands of loads of spent nuclear fuel we're talking about. And I might point out perhaps one of the most striking omissions from the application papers is this complete lack of discussion, lack of specificity about the probable transportation routes. We'll get into it, I'm sure, with the board's questionings, but essentially the Holtec position appears to be, all that's way off in the future, and we haven't made those decisions, and nobody can figure it out yet. It's just not knowable. And we think it's quite knowable, that it's quite imputable, because we've been here before. In the Yucca Mountain Environmental Impact Statement documents, there's considerable discussion of the national rail system. There's considerable discussion of the barge hauling, which is quite significant and almost invisible in any national perspective on this problem, and the highway travel that will be necessitated. So we're talking about an entire huge, what they call in my law school Latin, a sine qua non, without which the project is nothing. Without transportation, there won't be a Holtec. And transportation is a big issue because 218 million people live within approximately 80 kilometers, 50 miles, of the transportation arteries that we, to a pretty high degree of certainty, are certain will be used. Approximately, according to the application, I'm thinking somewhere in excess of 94 or 95% of the actual final delivery leg to Holtec will be by rail. Some of the early stages, however, which are kind of remarkable to me, will be barge-borne canisters of waste on the Great Lakes, on Delaware Bay, along the Florida Atlantic coastline, around Cape Cod, Boston's Bay, down through the river system, the Missouri, Mississippi, Tennessee rivers would all see barge hauling of this material. And as I say, we know this because we have an imperfect but somewhat analytical analog, I should say, already in existence. That being the work that was done, much of it through the state of Nevada and by the state of Nevada, on the transportation implications for Yucca Mountain. One of the things that is a grave distinction, however, is that Yucca Mountain, were it to become the repository, would only dispose of 70,000 tons, less than half of the contemplated storage in shallow surface burial in the desert of southeastern New Mexico. So this is a major national issue. The grassroots organizations and public citizens are here, in effect, as symbolic plaintiffs, if you will. They are interveners on behalf of the huge amount of the country's population that is potentially affected. One last point, and then we can certainly turn toward the issues, is that the 2002, where is it? Pardon me one moment where I try to decipher my left-handed scrawl. The 2002 Final Environmental Impact Statement for Yucca Mountain basically set forth a region of influence, and I've mentioned this in our pleadings, a region of influence out to the 80-kilometer, 50-mile radius, also stating that the area of immediate environmental effect could be 800 meters on either side of a right-of-way, whether it be rail or road, highway. And this was for purposes of assessing the transportation impacts in the Yucca EIS side of the proceeding. We believe that that's logical. It makes sense, and in fact, the Department of Energy, the name of which keeps recurring in these proceedings, might, if asked, strongly advise that the NRC consider it as a region of effect. With that, I'm ready to take your questions. Thank you.
Thank you. Judge DeCouros, did you want to begin?
Yeah, since we started in transportation, let me ask a transportation question. Contention 11, your contention 11?
Yes.
You say that you're referring to the shipments that you're now talking about, that they'll be subject to, if not vulnerable, to human-induced event risks over the lifespan of the transport campaign.
Correct.
And you say it is necessary to define, understand, and communicate design basis events so that communities along the transportation routes and at the initiation and destination points are risk-informed. Now, these design basis events that you're talking about, let's see, how do you relate those to the requirements of Part 71 and I think Subpart F of Part 71? But how do you relate? So what design basis events are you talking about? Are these something that has yet to be created and you're seeking that they be created? Is that clear?
Well, it's a little difficult to predict design basis events until you have designed transport casks and canisters. The problem presently is that it's our understanding that none of the existing storage casks and canisters on site at reactors will be ultimately the transport units used to haul the material to New Mexico. So first of all, there's that problem, which is rather a serious one. How does the possibility of sabotage or terrorist events relate to this project? Is that I'm not sure I understood your question, sir.
You're saying that there should be a set of design basis events defined that would risk inform the public along transportation routes of vulnerabilities associated with potentially terrorist events.
Right.
And what I'm asking is, what is the nature of these design basis events, and how are they different from the Part 71 requirements for transportation, for canisters and transportation casks?
Well, the nature of the design basis events is if there is a successful deployment of a tow missile at an in-transit cask, there could be a major environmental and public health event, and you thus have apparently not been able to successfully make a delivery that conforms with Part 71. I still am not certain I understand what you're asking for here.
Are you suggesting that Part 71 requirements are inadequate?
I'm suggesting that compliance with the Part 71 requirements encompasses a lot more than the applicant is suggesting. In fact, one of the problems that we have identified is that 71 talks about ISFSI facilities, and I think the conventional understanding of an ISFSI is not the Holtec waste facility. A standard ISFSI is maybe a few hundred or a few thousand tons stored at a reactor site, or maybe a combined storage event at a reactor site. It is not 173,000 metric tons having traveled millions of miles to be congregated. And I think that a realistic reading of Part 71 and applying it to this project is going to definitely imply a much more expansive sweep of the implications and the necessary steps. One of the problems here, and it certainly has been discussed well beyond the threshold, is the legal problem of whether the facility is even lawful. And along with that, there is a paucity, because of the way the NWPA is written, there are not adequate regulations that envision this type of facility. There is discussion in the NWPA of a CISF, a Consolidated Interim Storage Facility, but it's tiny in comparison to this. It's minuscule. And of course, it's not even within legal reach at this point. So the point is, yes, Part 71 is there, and yes, it must be obeyed. And no, I'm not suggesting that we challenge the rule, but I think that the rule must be read in the most expansive possible way.
A quick question on the Part 71 transportation.
Yes.
Does that have an automatic opportunity for hearing in it?
For what?
For a hearing like this?
This is, I would say probably not.
So as far as you know, it's either you're heard now on transportation or you're not heard at all?
I'm not sure I agree with that notion. This is not a substantive hearing. It is merely a procedural one.
Right.
And I don't recall, well, to answer your question, number one, I want to correct myself. Part 72 is what governs the dry cask storage regulations. Part 71 is the transportation regs, of course. But I think that transportation is the essential element without which the project is it's a non-starter, it's an impossibility, even if you assume that the legal hurdles have been successfully crossed. So we believe that transportation, by unspoken implication, has been segmented out of the project scope.
It sounds to me as if you're saying that there should be a separate analysis that is, so to speak, a risk study on transportation, and that as a result of that, there should be defined a series of events which are not currently incorporated into the current regulations, Part 71, and that should form the basis for what? You say risk informing the people along transportation routes, so I'm not sure, I don't know what that means exactly. So to what end would all this be taking us?
Number one, it wouldn't be necessarily a separate study. It would be part of the draft environmental impact statement. Number two, of course, as the panel is well aware, part of the purpose behind an EIS is to inform the public, but also to signal to the public that the agency itself has both consulted other agencies and taken into account the maximum number of reasonable scenarios, reasonable problems, and environmental impacts that might befall were the project to go forward. So we believe that it's a very reasonable request, and NEPA trumps Part 71 to the extent that NEPA is not in conflict with Part 71. And we believe that the nature of this unprecedented project is something that demands a much fuller transportation analysis than has been done and has largely not been done. I just want to point out the data that we've been relying on to identify probable transportation, mainline rail routes, mainline highway and water routes, is taken from an entirely different project's EIS. That's how low the level of information is within this document. And it will involve a lot more waste and a lot more travel. And let me tell you why it will involve more travel. It will involve more travel because this is an interim site. So the material goes to New Mexico and then supposedly would go ultimately to a repository in another location. And the way Holtec has proposed to manage this waste, they actually reserve the right that a non-conforming shipment delivered to the site can be returned to the originating reactor site, or now, in the last week and a half, we've learned that they're proposing it might also be diverted back to a site that can remediate a damaged or leaking or contaminated canister.
Okay, thank you.
Thank you.
Let me move on to contentions 5 and 12. And my concern here, well, let me just say that I can read contention 5 to be human activity that may cause some geologic effect on the plant, on the facility.
Yes.
I can read the other contention, 12, to be naturally occurring geologic conditions.
Right.
Okay. So I'm reading those correctly.
Mm-hmm. Yes.
So I would first ask the question, is subsidence of the land something that you believe would damage this facility?
Yes. I'm not a geologist, but I suspect that in the Permian Basin, there has been a study, a juried study within the last year and a half or so, that has pronounced that in the last 3 decades, more or less, there's been, in some places, as much as a 40-inch change in elevation. And yes, subsidence, that's enormous. You don't have to be a geologist to know that that's incredible. So yes, and the Permian Basin is either at or fast approaching the status of the most prolific, productive oil and gas patch, certainly in the Western Hemisphere, if not the globe. So, and it's not showing any signs of slowing down in the coming decades. So there are going to be new geological problems, including seismic events, that we believe have to be taken into account.
It's your position then that the environmental report and perhaps the SAR did not adequately account for these geologic conditions that you're worried about?
That is correct. And I might add that from what I understand, the Holtec location is within this, I'm thinking it's about 20,000 square mile Permian Basin area. The Holtec location is near the most productive zones. And there is presently fracking going on 2 or 3 sides. And a major potash mining facility, I don't know if it's presently operating, but certainly there's been geological disturbance from a potash mining facility hard by the site.
In your contention 12 pleading, you reference a report from your consultant, and that report provides a sort of different geologic picture than the environmental report in some respects.
Yes.
It's just a cursory look at differences between them. You know, I could see that section 2 of your report talks about the nature of the valley there, and it ends by saying the Holtec site appears to be sited on top of a karst valley, an extension of well-studied nearby karst valley that has undergone subsidence. Section 3.3 of the environmental report says, comparison of conditions at the site with those conditions favorable to karst development indicates that conditions at the site are not conducive to karst development. Now, you couldn't be any different than that. The one says very much karst valley, the other says no. But yet, in your pleading, you didn't point to the application. You didn't connect your consultant's report to the application. It isn't my job to find such discrepancies. It is your job to find such discrepancies and report them as in the contention. How would you answer that?
I think you've summed it up correctly. I believe, however, that the distinction that Your Honor just noted reflects an issue of fact, and we aren't even required and compelled to meet a prima facie standard of evidence and proof for purposes of admitting a contention. I think it is the distinction, the difference in factual position is sufficient to warrant admissibility of the contention and further investigation.
So you're telling me that you don't think you really need to tell us what's wrong with the application, that just the fact that that information is out there to be found is sufficient? Is that what I'm hearing you say?
No, sir, I'm not making that brazen of an assertion. I am saying that the obviousness of the factual controversy is such that there should be a contention.
Your contention 5, it's rather simply worded, horizontal hydraulic fracturing, parenthesis fracking, is certain to occur underneath the site. From what I can see, that's not in dispute. What is in dispute is that the fracking will occur at depths in excess of 5,000 feet.
Yes.
And statements are made that at that depth, there's absolute assurance, in essence, that there won't be any effect on the facility.
If you're referring to statements that we made in our petition, that's not inaccurate.
No, these are, when I look at your petition, I also look at the answers from Holtec and the NRC staff.
Just wanted to clarify that point.
Yeah. Clearly that wasn't something you said.
And as we were just discussing a few minutes ago, there is scientifically documented subsidence going on. So yes, there is certainly some distinct likelihood that there will be geological effects noticeable at or near the surface. But the problem here is this facility has to be run perfectly. It effectively, the radioactive waste and the radiation must be contained as perfectly as possible for a very long time. And the stability of these canisters for 100 or 120 years is going to be an ongoing experiment. We've never done this before. So we believe that the balance of equities certainly calls for there to be more, not less, investigation via contentions.
Okay. To your knowledge, is there any level of subsidence that could be tolerated by this facility?
I'm not a geologist, and I don't consider myself qualified to say, but I would suggest that we're talking about subterranean platforms of human-installed and dense material that are going to be rigid and not very flexible and may be cracked or otherwise fissured, both by the unforeseen problems with the weight from above as well as from shifts from below. It just seems to me, from a lawyer with a poli-sci degree, that what we're looking at is geology that has not been tested nor fully explored nor explained in the context of not just active oil drilling, but the most intrusive form of extracting gas and oil, which includes underground explosions to create caverns into which to inject under high pressure industrial chemicals to draw out the oil and gas. We don't know what that's going to mean over the next 30, 50, 100 years. We don't know what geological changes will be induced. Very little of our geological understanding of the Earth's crust is gleaned apart from oil and gas development.
The statements are made in your contention that the activities that are taking place in the surrounding area of the Holtec site are similar to what types of activities would take place at the Holtec site, including fracking below 5,000 feet.
Correct.
And you also state that the surrounding area has exhibited signs of subsidence.
Correct. Not necessarily the immediately surrounding area. I don't believe the analysis that was published a year or so ago was that close to Holtec, but it's in the Permian Basin.
Also, the environmental report, I think it's page 344 of 482 as on a PDF relative basis.
Right.
Says the SAR at I think it's page 254 indicates that there are no surface drill hole or mining indications that subsidence and collapse chimneys occur at the site. Basically, it's saying subsidence is not a safety concern.
No, and the facility may not even be operable for some years to come, during which time there will be incrementally more hydrofracturing activity in and around the site, and maybe even underneath it. You know, as I was writing that contention, I was thinking to myself, what would it have sounded like in the Yucca proceeding a few years ago if oil and gas companies were clearly and rather nakedly announcing, sure, we're going to frack right around Yucca Mountain. What's the problem? I think it would have been an enormous problem, not just scientifically, but from an image, optical standpoint.
So your consultant believes that subsidence is a concern at the Holtec site?
Absolutely, yes, sir. And seismicity, I think, is a concern that is increasingly becoming attached to the presence in the area of fracking.
Thank you.
Thank you.
I think we'll take a break shortly. Just one or two questions that I have at this point. Following up on Judge Takuros' comments about grappling with the application, if you will. I mean, the commission has said and I think I have this as almost a quote, the staff will correct me if I don't. The commission has said that petitioners have an ironclad obligation to read the application and to identify genuine disputes with the application. And, I mean, do you disagree? I mean, we should follow what the commission says on that. Don't you agree?
I'm aware, certainly, of the commission's pronouncements. I think, however, and this is not necessarily to differ with them, I think the obligation has been met with the evidentiary presentation we've made. I think that there is a tendency to overinterpret what the commission actually seeks, because, as I say, a prima facie standard isn't even applicable to the evidence here. We're demonstrating some controversy in fact, and that should be legally sufficient to go forward with contention being admitted. And I've been litigating NRC cases for a long time and have certainly learned a lot about draftsmanship. But I do believe that we've met the standard to present information that a reasonable examiner of the pleadings would find that there is sufficient evidence of a controversy to go beyond this stage.
Okay. Thank you. I have just one more observation, really not a question, but more of an observation. And I think I understand that there are contentions that challenge how long these, quote, interim facilities might be in operation. But we should not forget, and I urge all petitioners as you make your arguments to remember this, that the Yucca Mountain facility was remains subject, if it comes back ever, to a set of regulations that contemplate standards that will be met for the period of geologic stability. The period of geologic stability in the Yucca Mountain regulations is defined as 1 million years. Mm-hmm. That is longer than 40 years, it's longer than 100 years, it's longer than 120 years. And so I think as you make your arguments, be a little careful about drawing too direct analogies to Yucca Mountain. They are very different proceedings, I think, in the board's view. But let's move on. I think if we take a break from now until, say, 3 o'clock, we need to finish at 4:30, so we can take one break till 3, and we will then go till 4:30 today. Thank you. Mr. Lodge, one moment. I have an announcement or two to make, and then we'll get back to you. Just two announcements. We have, with the NRC, has reserved and paid for this space for 2 days. So apparently, if you have heavy binders or anything and you want to leave them, there will not be a cleaning crew coming in. You may do that. I wouldn't do it myself, frankly, but that's an option, just so you know that. There were some questions about timing. I think we said we will start tomorrow at 9, and we were asked when we would finish, and that kind of depends on how long the questions go tomorrow. So my best guess is that we will finish that we will finish before 4:30 tomorrow. Whether we just have a morning session or not, I just don't know. But plane tickets. Oh, you know, the number of people who was on the flight that at least who was on it, we were on it. That's right. We should take a break tomorrow at 10 o'clock so that people can sign in to their Southwest reservations. All right.
Maybe they could just...
We might do that, actually.
Maybe you could just have a scanner installed in the lobby from the airport.
All right. We are back to examining Mr. Lodge.
Your Honor, before we proceed with further questions of me, I have a couple of things I would like to respond to. One of them is to supplement my response to Judge Trikoros. In March 2018, the NRC staff sent their first request for additional information, RAIs, to Holtec, and RAI 2-2 specifically, I haven't seen the responses, but the staff requested assessments using site-measured geotechnical properties to demonstrate that the soils at the subgrade and undergrade of the storage pads and the canister transfer facility would be able to withstand the loading assumed in the certification of the high storm UMAX canister storage system. It goes on to describe expressly what data they're looking for, but clearly the staff is concerned that the analyses should, quote, demonstrate that the subgrade and undergrade soil properties at the high store CIS site are uniformly better than those assumed for the general certification of the high storm UMAX system. So the staff is indeed also concerned that there not be a human-induced geological change just from the fact of the great weight that will be brought into the area of having this facility. And Judge Ryerson, in response to the comments you made just before the break, I believe that Your Honor was referring to the post-closure requirements at Yucca, which indeed do require, impose certain standards out to 1 million years. But there is some analogous pre-closure application information that had been submitted by DOE governing the approximate 50-year period of actual operations of the Yucca facility. And those particular requirements have been conformed to Part 50, which is fairly analogous to Part 72 requirements. So the Yucca operations, which incidentally have, as things were left at the last cliffhanging episode a few years ago, the Yucca requirements are that there will not be any loading, unloading of canisters at the Yucca site. All of that has been moved upstream, if you will, into CISFs and or reactor sites. Thank you.
Thank you. I think now Judge Arnold has a number of questions for you, Mr. Lodge.
Your petition, this question will be familiar, lists the 10 CFR 2.309F criteria for admissible contention, including item 3 that it be within scope and item 4 that it be material to the findings the NRC must make. Most of your contentions did not address either of those. So would you tell me, do you think your contentions are in scope and material?
Yes, we do believe that.
Also, you make numerous references to the Nuclear Waste Policy Act. What evidence do you have that that is relevant to this licensing procedure?
It's a good question. It certainly should be, and we believe that it is being violated in not being observed properly by the license, no pun intended, the poetic license that's been granted to Holtec to pretend that there actually would be two financing streams instead of utter dependence on DOE for cash and liability protection.
Okay. Concerning contention 1, as I understand it, you're not objecting to the fact that you don't have access to the redacted pages, but rather you are claiming that the redaction itself is a violation of the National Historic Preservation Act. Is that correct?
Insofar, yes, it's correct, but it is also violative of NEPA because it is another review that has to be addressed or mentioned and disclosed in some respects in NEPA. So yes.
Okay. In their answer to your petition, staff cited the Section 304 of the National Historic Preservation Act as their authority to redact the information. And in your reply, you seem to go further into depth as to the process of obtaining access to Sunset being unreasonable. Are you changing the focus of your contention, or do you think this is still under the same contention as originally?
That was simply a rebuttal argument that we were making. And in fact, I was looking in the last few days at the latest revision of the environmental report, which still contains enormous redactions. The thing that jumps out is that literally 1/4 of the pages of the ER have been redacted for this apparent cultural properties purpose. And if we're talking about this being the foundational document from which the DEIS ultimately may be formed, you're talking about depriving the public of access to what cultural resources are threatened or actually going to, if the project goes forward, be destroyed. And the public has, under the NHPA and thus indirectly under the NEPA, has a mitigation comment and input opportunity, which is being denied. And at a minimum, we have a contention of omission. I might add, there have been, I think I've seen an REI or other correspondence between the NRC staff and possibly the State Historic Preservation Office of New Mexico, only dated in September, so that there's finally some movement on the NHPA aspects of this. But again, that letter, as I recall, even continues in effect the redaction and confidentiality.
Concerning contention 2, having to do with reasonable assurance that it can obtain the necessary funds, in your consolidated reply to Holtec and NRC staff on page 25, you state, Holtec has presented essentially 2 applications to the NRC. One postulates a legal pathway to financing and commissioning, but is economically improbable, and the other one lays out a legally impossible pathway. Let's say that you're correct, and that one pathway is illegal. If the license is granted and the DOE can't get title to the license, then what happens then? Would they be able to run a consolidated facility just for the utilities, or are you saying somehow that license still wouldn't be valid?
Well, license validity, with respect, is not so much the issue as financial reality. And it's my understanding the Price-Anderson Act will not attach to a private facility. And that means that 10, 30, 50, 80,000 shipments of spent nuclear fuel done as a supposed private enterprise project will all be uncovered, unless, of course, there's some brave underwriter out there in the global economy willing to cover the possibilities of a serious nuclear waste accident. The problem here is that it's not just improbable. We think that in practical terms, the private sector stream of financing is impossible, and that it is only used as a means of camouflaging the DOE thing. I'm troubled by the fact that one of my law school, the things drummed into my head was that courts do not exist to give advisory opinions on theoretical questions. And administrative agencies, you are the trial court. You are the quasi-judicial body. You're the trial judges, as you well know. And effectively, this is a request for a theoretical what-if opinion. And we believe that just following that simple principle, this board and the commission itself cannot possibly entertain this application. Thank you.
Contention 3. The environmental report is incorrect in that it contains a gross underestimation of the volume of low-level radioactive waste that will be generated by the use of concrete and other materials for bunkering the spent nuclear fuel canisters. Now, I looked through the ER and I could not find any estimate of the volume of low-level waste. Could you cite to where that is? All I could find was small.
I believe it's in the GEIS. I think that's what the applicant is assuming would be generated.
Okay. And you don't know what the value was of that?
It's in the Holtec answer. It's a tiny fraction of 8 million tons, I can tell you that. I think it's something on the order possibly of fewer than 200,000 tons. And incidentally, Your Honor, again, this raises the specter of that 800-pound gorilla, which is that depending on where the loading of the TAD, the transport and disposal canisters occurs, whether it happens at the reactor sites or if it happens at Holtec, there could be a very significant change in the volume of low-level radioactive waste generated as a result of the Holtec project.
Do you have any factual support for your assertion that concrete would become radioactive?
Other than common sense and the fact that even in its answer, Holtec basically quibbles with our number, but not with the phenomenon that irradiation can and will occur in the immediate vicinity. If these canisters are emitting seriously public health threatening measurable radiation at 6 feet when they're being transported, they certainly are going to continue to emit neutron and other radiation for a long time in place, in situ.
Now, I inferred from what you said that you also believe that if it does become radioactive, that it can't be decontaminated. Do you have any support for that?
No, and we weren't making the argument that it is impossible to decontaminate it. We were making the argument that the initial quantification is tremendously off base.
On page 41 to 43 of your petition, you discuss the cost of repackaging spent fuel for disposal, citing the Alvarez report as support. How would the overall cost and waste disposal differ between having this central facility and having it at individual IFCs? I mean, wouldn't the same repackaging be needed?
The answer to that question is yes. And the assumptions, of course, in the Alvarez report were that, I think that was the Columbia station, but that if it were done there, here's what we estimate. And Alvarez's point is that I think the ultimate, if we're talking about DOE taking title, the taxpayers are not having it fairly explained and disclosed to them what the real costs of just having this interim storage way station for 100 years will really be. That act is going to have to happen somewhere, the recombination, if you will, of the waste into different canisters. And as presently explained to us, the Holtec proposal is they will take all canisters, they'll take all comers, regardless of brand, which I think NAC is here to dispute, but that none of those will be appropriate for use in a geological repository. So there's going to be an enormous expense point that is not disclosed, not quantified, not discussed.
And since Yucca Mountain or any other repository doesn't seem to be right on the horizon right now, I would not expect this repackaging for disposal to occur within the current licensing period. That being the case, why should it be discussed in this application?
With respect, you're assuming that it may not happen in this licensing period. The fact is it's going to have to happen. And the additional fact is that you do raise the interesting problem that Holtec itself has said that an appropriate, robust CISF needs to be able to operate effectively for 300 years, not 100 years. This is an important compact with the state of New Mexico that the material will move after a certain specified period of time. And we think that probably serious gestures technologically preparing the waste to be moved to an ultimate repository is going to be a necessary matter. And regardless of the time frame that Your Honor suggests, the scope of this project is 120 years. And it is incumbent upon the NRC to consider the environmental impacts, which includes economic effects, out to at least that period of time. And just as we're told that we need to change our expectations of the CISF, one of those expectations is it will be time limited, and it will only be a waste station which prepares or at least ensures uniformity of the waste to be moved to its ultimate destination.
Okay. On to contention 4. Severe accident mitigation during transportation to and from the Holtec CISF and at the CISF. And spent nuclear fuel and greater than Class C storage and management operations at the site may not be treated as generic issues and excused from consideration within the EIS. Now, on page 47 of your petition, you argue that the Holtec waste storage facility cannot be covered by the continued storage GEIS because the GEIS assumes the facility will have a dry transfer system. But you go on to state, continued storage GEIS finds there is no dry transfer system capability anywhere within the United States. And that suggests that the logic says the GEIS applies to no current ISFC. Would you agree with that?
Yes.
Okay. On page 48 of your petition, you argue that the generic EIS is not applicable because the Holtec facility is much larger than the hypothetical storage facility, or the one used in GIS. Would this particular objection go away if the Holtec facility was for 40,000 metric tons, the same as assumed in the GEIS?
Well, first of all, it isn't. Right. We're talking about something that's nearly 4.5 times the size. But secondly, the problem is even with a 40,000-ton facility, you would be looking at some commitment at some point within that first century to having a DTS present. Our logic, if that's the right word, behind this is when you have such an enormously larger volume and larger number of arriving cargoes, the odds increase that there will be a need for a DTS. And incredibly enough, in the last week and a half, second-round RAI responses that have appeared in Adams indicate that Holtec itself now believes that their return-to-sender system has to contemplate having the presence somewhere, not on the Holtec site, of a DTS system. In an RAI response, they actually say that if they find non-conforming casks that are leaking or are contaminated externally, what have you, that they will be held on a siding and ultimately returned to the originating reactor site or diverted to a site with loading capability. So now Holtec is sort of starting to faintly mimic the theme that, gee, somebody's going to have to be able to fix these.
Now, the current license application is for a facility holding only 5,000 metric tons, not the whole 100,000 metric tons. So does this specific objection that it doesn't match the size assumed for the GEIS still hold for this licensing action where they're only looking for 5,000 metric tons?
Yes, it does. And we believe that the 20 different licenses of 5,000 each is probably calculated to get around some type of statutory difficulty. Again, the entire project is what must be considered at this early phase of the planning and licensing, and that's what NEPA's there for. If I may, I would just like to add one more.
Sure.
All right, thank you. Let's proceed.
Okay. Next question. On page 49 of the petition, you state, quote, the Holtec CISF does not qualify under NRC regulations as an ISFC. Now, I took a look at 10 CFR 72.3, where it provides definitions for that section, and it defines an ISFC as an independent spent fuel storage installation, or ISFC, means a complex designed and constructed for the interim storage of spent nuclear fuel, solid reactor-related greater than Class C waste, and other radioactive materials associated with spent fuel and reactor-related greater than Class C waste storage. What part of this definition is not met by the Holtec CISF?
Broadly, Holtec falls within that definition, but this has also been called a monitored retrievable storage facility. The problem is it's far different from what I think the drafters of the ISFSI definition contemplated when they wrote that regulation. I return to my earlier point that we believe that a much higher standard of scrutiny and data inventorying and investigation and disclosure has to happen.
Sure. Just one point on that, Mr. Lodge. I mean, there is a procedure in the rules for challenging rules in special circumstances, which sounds to me like that's sort of what you're saying, that you have here a situation, we have a situation that you say was not contemplated when the rule was enacted. Therefore, there's special circumstances. But you haven't followed that option. That option requires certain requirements in your filings, and very importantly, if we agree, it requires, I believe, immediate referral to the commission. So why have you not followed that route if you feel there are special circumstances that make the rule no longer serving the purpose for which it was promulgated?
Well, Your Honor, the problem is, number one, that is a very complex process. Number two, while we're continuing to look at the possibility of a petition for rulemaking, as I've said, I grudgingly admit that, yes, this is an ISFSI viewed through one prism, but it's not an ISFSI that anyone has ever seen before. And it's much, much larger. It involves a lot of management that is only contemplated and being conceptualized now. So it's difficult to simply say point blank that it violates the rules and get us into the challenging irregulation territory. I'm not quite sure that that's really the appropriate approach. That's the best answer I can give you.
Okay, thank you.
Contention 5 has to do with mineral interests below the site.
Right.
But on page 52 of that, you make reference to chemically aggressive wind-blown dust. Mm-hmm. What exactly about the dust is chemically active?
The nearby, I think, lakes that periodically sometimes go dry have been dumping grounds for decades, at least back to the late 1960s, for oil and gas and drilling waste, which could contain a lot of acidity, a lot of corrosive material, heavy metals, even radium. And that material is possibly, likely being incorporated into dust, and there are very serious dust storm events in that part of the state.
Okay.
Incidentally, I think, if I'm recalling correctly, that the volume of waste that was being dumped was in the millions of gallons per year over the decades. So there's possibly a great deal of contamination present.
Contention 9, potential transportation routes are not all provided. 10 CFR 72.108 states the proposed ISFC or MRS must be evaluated with respect to the potential impact on the environment of the transportation of a spent fuel, high-level radioactive waste, or reactor-related greater than Class C waste within the region. And it makes no mention of transportation outside the region of the ISFC. So can you point to anything that requires them to look at transportation throughout the United States?
Well, that is one of the poorest drafted regulations I could imagine, because there's an extensive argument, I think, in either the staff or the Holtec answer, saying, here's how we'll have to define regions, since it's not defined within the regulation or within any companion regulations. And my counter to that is, region could mean the 50-mile radius region of influence. It could mean the southwestern geographic region of the United States. Unfortunately, it's a regulation. Nobody thought to adequately define what region means. And so I think that it is valid to, I think this also, that it may not have been drafted in contemplation of a 20-year or longer massive campaign of thousands of cargoes of spent nuclear fuel. And I believe if that's going to be the reg, that it must be interpreted as liberally as possible, up to and including the, 40 states or so through which nuclear waste will travel to go to Holtec.
Thank you. Contention 10, NEPA evaluation should be performed for operation exceeding 100 years. Now, the continued storage rule kind of says that you don't have to evaluate environmental effects beyond the license period for the current license. So how can we look at that and not consider it a challenge to the continued storage rule?
First of all, that we provide some evidence that suggests, even from Holtec, that there may be actually contemplated a 300-year period of operation. It may be a challenge to the GIS but if you link it to our objections as to the validity of applying the GEIS to this situation, this is not comparable to the prototype, the PFS facility that was actually the prototype in the generic environmental impact statement. This is not, it won't have a DTS. It'll be 4 times the size. There are some other technical differences that are pretty serious distinctions, and we believe that the GEIS may not apply, just period, in any type of objective assessment of things. And further, there is the, as I say, the additional, what I consider to be the contract with New Mexico. The original contract between DOE and New Mexico was, if you'll take WIP, we won't do this to you again. And now we see what detrimental reliance will mean when assessing having another possibly DOE-funded facility in New Mexico. So the problem is, Your Honor, I'm not sure that the GEIS validly can be construed to have effect here. And if it does, that's a most unfortunate thing for purposes of full and genuine public disclosure.
Okay. On to contention 11. Regulators should consider the risks, impacts, and safety security for the Holtec CISF radiological waste transportation effort. Now, on page 77 of your petition, you discuss the Ninth Circuit Court decision in the San Luis Obispo Mothers for Peace case.
Yes.
But on page 4-91 of the GEIS for continued storage, it states, quote, in 2009, the Court of Appeals for the Third Circuit upheld the NRC's position that terrorist attacks are too far removed from the natural or expected consequences of agency action to require environmental analysis. Now, this Third Circuit Court seems to be more in line with NRC regulations, so why should we be more influenced by the Ninth Circuit Court than by the Third Circuit Court and NRC policy?
Well, I believe the NRC regulation actually has largely come after the Third Circuit decision. It's sort of interesting. The NRC apparently decided to be the Supreme Court and decide which circuit they were going to approve and follow and which they would not. Yet, the Ninth Circuit decision is still good and valid and binding in the 5 or 6 states that comprise the Ninth Circuit. It's a terrible conundrum. I think it's unfortunate that there is not some type of uniform policy, and I'm troubled by the fact that the NRC did not at least allow the Supreme Court to make a pronouncement instead.
New Mexico is not, for the benefit of people who are not lawyers, New Mexico is not in the Ninth Circuit, correct?
No, but you're correct, Your Honor. But hundreds of shipments will come through the Ninth Circuit en route to New Mexico.
I haven't really formulated a question here. I will have a question for Holtec later about transportation of spent fuel from the jurisdiction of the Ninth Circuit Court. Do you have any comment on that?
I think that the Ninth Circuit law must be respected and abided by within the geographic territory of the Ninth Circuit.
So if Holtec ever wants to take Southern California Edison spent fuel or Diablo Canyon, they've got more work to do.
Correct.
That's the end of my questions.
Judge Shiguro.
Yeah, just some follow-up. You mentioned an RAI that the staff issued fairly recently. What was the date again of that RAI?
About respecting what?
This was with respect to the contention 12 and contention 5 discussion on subsidence.
Oh, I don't know. I haven't seen the response, but the RAI itself was was put by the staff to Holtec by letter dated March 28th, 2018.
Okay, and is there a response, or is that pending?
I'm not sure. We think that they may have, that the company has approval to respond by the end of February of this year.
Okay. And just one other point. With respect to possible effects of fracking below 5,000 feet,
yes.
Was it your position that would have an effect on subsidence at the site?
I'm not a geologist. I
understand.
Our concern is...
Your contention was sort of nebulous.
Yes. Our position is that I can't definitively say that it will have an effect on subsidence, but there's some very disturbing evidence in the, you should pardon the expression, region that suggests that it must be examined much more fully. The Permian Basin, they can't get enough workers. They're importing workers from all over the United States and Canada and Mexico because this is such an oil and gas boom. And it's going to continue into the indefinite future. They can't get enough equipment. They're desperate to construct pipelines to move the product out of the area. This is a huge booming thing. It's not just a passing trend. Thank you. Anything else?
Yeah.
Did you have another question?
I just wanted to finish by saying, so the way you left it was that there are regions in the vicinity of the site that are doing hydraulic fracturing below 5,000 feet and are experiencing subsidence, but there's no scientific correlation of the connection between those two.
Oh, I think that there's definitely some scientific correlation. I think it's an SMU study that came out approximately, I'm thinking, a little more than a year and a half ago. It certainly does suggest there's a relationship. Fracking, the geological effects of fracking on a large scale type of basis are finally being scientifically understood. And the Permian Basin is providing a lot of experimental data.
All right, thank you.
Just one final follow-up, Mr. Lodge, on your standing arguments. For your 7 petitioners, am I correct? Do they all base standing on proximity to transportation routes? None of them is within 50 miles of the proposed facility, for example. Is that correct?
I believe it is correct that none of them are within 50 miles. It is not completely accurate to characterize our standing arguments as being solely based on proximity, however. We are also relying to some extent on the actual injury enunciated in the Kojima Stone-Webster decision. And there is additionally another NRC site that I cited in our filings. You just give me one moment, please. It's a Millstone case. It's a Dominion nuclear case that says that the mere threat of actual injury is sufficient to confer standing. But we believe that we've established in many instances with various declarations from the different putative interveners that they live in many cases within a mile or 2 or 3 of a highway or railroad track that they believe to be a main line. And again, that gets us into the dispute over how could we possibly know or suspect what the main transport arteries will be. But there is proximity, and there is also the possibility, because they live, work, and recreate within a small radius, there is the possibility of direct injury.
All right. What I was going to ask you, and I think you've just given me the answer, as you know, we tend to follow commission decisions. We sometimes find other board decisions persuasive, and I was just really going to ask you for your best NRC cases. I think you have given them to me, correct?
Yeah, they appear in our written arguments, too.
Yeah. Anybody else? I think for the moment, anyway, we're done. Thank you, Mr. Lodge.
You're welcome.
So we have 45 minutes or so today, plenty of time for at least one more petitioner, Mr. Desai for NAC International.
Thank you guys very much for having us. May it please the board, I guess I'll just jump into it given time constraints. If it may please the board, I'm Sachin Desai, counsel for NAC International. I'll start with a general opening statement explaining why we are here and the critical issues with Holtec's universal CISF approach. Bob is available to help us with questions as they come up. NAC International is an international supplier of canister, and spent fuel management services to the nuclear industry across the world. We know this industry inside and out, and are involved in the Interim Storage Partners Consolidated Interim Storage Facility project down the road. We're not opposed to Holtec getting a license to a CISF, generally speaking. We think that a Holtec CISF that used Holtec canisters and casks the old-fashioned way would help address the nation's complex challenges with managing spent nuclear fuel. But there is one fundamental issue with Holtec's approach, though, that brings us here today. Holtec's desire to use a universal cask system as the basis for the CISF. They want to take non-Holtec canisters containing spent nuclear fuel and place them in their own Holtec UMAC canisters at this CISF, without the original equipment manufacturer's consent or assistance. This has never been done before, for good reason, and creates two distinct safety and environmental concerns joined by a single core issue. We'll get into the scope of the license application and the detailed legal issues during the argument itself. But not to mince words here, Holtec's stated goal for the project is to store non-Holtec canisters, essentially taking ownership of this product. As we stated in our petition at page 8, footnote 8, the Holtec website made the bold assertion as of the petition date, and still maintains that statement as of when we last looked, that the high-store CIS will accept a loaded canister of any provenance, whether they are horizontally stored canisters in Areva's New Home system or vertical canisters in NAC's system. This is what they're marketing. The first page of the transmittal letter to the Holtec's application from March 30th, 2017, states that the high-storm UMAC canister system has been engineered to store entire complement of canisters currently deployed at ISSCs across the country, a technical assertion. And the ER, of course, reiterates this universal concept a couple times, particularly relying on the universal cask system in the alternatives analysis in section 2.4.1. An assertion the staff agreed was incorrect in its answer to our contentions. And there's more in the reply. Now, with regards to the ER, there's something worth explaining here that gets to the board's questions and to Holtec's answer. Note that Holtec's language in the ER, which is still maintained despite Holtec's admission in its answer that it doesn't have an actual universal system, still is there in the ER for 2.4.1. This is because the ER looks farther out than the specific license application. It has a broad purpose and need statement to store S&F from all plants across the country, operating or not. The license requested by Holtec covers just phase 1 of the CISF, like 8,700 MTUs. But as described in section 1.3 of the ER aims to cover all impacts during the full 20 phases of the project, 100,000 MTUs and 10,000 canisters. This forces Holtec to have to evaluate now how it will deal with non-Holtec canisters, such as NACs, as part of this environmental report. And because it's being addressed now, NAC won't get a chance to deal with it later. Now, to make this goal happen, Holtec's relying on its universal cask approach as the centerpiece of its proposed CISF and the ER design alternatives analysis. This approach is a significant departure from the standard reasonable alternative designing a CISF, in which one vendor, like NAC or Holtec, inserts its own canister into its own casks. This is the approach that is used at pretty much, or at every ISSC across the country. Even if there's multiple vendors, one will put its own canisters in its own cask. Now, we actually adopted an alternative, which is the alternative that was in ER 2.4.1, which is the approach at Interim Storage Partners facility down the road. We call it an open vendor approach, in which different vendors can work together to share one ISSC space or CIS space, but not mixing cask and canisters. This is the reasonable alternative Holtec was alluding to, and then declined to evaluate in section 2.4.1 of the ER. And we cite to the IRC project and petition and amplify this point directly in pages 11 and 12 of the reply. Now, to note, though, we can discuss alternatives in more detail in response to board's questions or Holtec's answer, but we don't need it for our contention to get in. Simply having an incorrect basis to decline to do an alternatives analysis is sufficient under NEPA regulations, NRC regulations, NRC guidance. The NEPA regs, the requirements for the ER tie back to the NRC regulations because 51.45 requires the alternatives analysis, which then goes to NRC guidance. In addition, there was a point was asked about whether you need proprietary information to do any such alternatives analysis. You don't. There's a whole NEPA consultant industry that's designed to do alternatives analysis and look at things like this. Nuclear power plants have to do alternatives analysis comparing to natural gas plants. Actually, PFS has to do alternatives analysis. We cite the PFS. So we mentioned there are reasonable alternatives, but we don't need that for our contention to get in. Now, turning back to the statement, there are reasons Holtec's approach to designing a CISF is not standard. Properly storing spent nuclear fuel requires complex analyses of the cast canister interaction to deal with normal, off-normal, and accident events, such as earthquakes, fires, and drops. This requires access to proprietary information held by the canister vendor. We described this throughout our petition and through the George Carver affidavit, which has gone unrefuted. And to further drive this point home, we cite to PFS, which had a lengthy second hearing, which was all about whether a canister would rupture in regards to a design basis event. Now, challenging an application before a licensing board is an extreme action, and one we would only do if the circumstances warranted it. We've tried to make our voices heard before in multiple ways. We've discussed it with the NRC staff, and both us and AREVA have written letters to the NRC. That we draw those to your attention in footnote 27 of the petition. In particular, we wrote to the NRC staff directly challenging Holtec statements in 2.4.1 of the ER, Contention 3, back in August 10th, 2017. We wrote to them at the time that this was misleading. And to this end, we believe the staff has recognized the concerns raised with Holtec's universal CS approach. Turning to footnote 26 of our petition, they've sent requests for information questioning how they can justify adding an Orano cast, for example, to the UMAX system. But Orano canister. But we haven't seen progress until now, until we've actually gone and done this activity, this filing of contentions, to deal with the marketing. In fact, it's actually Holtec's inability to close the UMAX Amendment 3 process, combined with still marketing a universal CISF and a universal UMAX CAT, that leads to confusion about the scope of this application. It was only until we made our stand here that Holtec now admits in its answer that the CIS license, if granted, would not allow storage of NAC canisters at the CISF. And after deferring on our August 10th letter, the NRC staff agrees and that our contention about relying on the universal canister is incorrect. So as a result, we've actually made great progress through this proceeding. But until Holtec actually stands down on its claim of a universal CIS system and analyzes an alternative of a non-universal approach, which is the standard for any CISF or ISSC, we need to remain involved. Unless Holtec does these two things, the risk exists that an inadequately analyzed Holtec CISF can store NAC canisters in Holtec CAF at some point in time, and he would be subject to harm from radiological incident or NRC regulations, or the variety of things we talked about in our petition, again, which were not really responded to in the answers. And to remind the board specifically regarding our environmental contention, Holtec and the NRC staff answers that the license application does not consider a universal CIS, CAS, or CISF, does not apply to the ER. The ER covers impact across all phases of the project. It's explained in section 1.2 and 1.3. If we don't get our voice in now, a key part of Holtec's path to getting an actual universal CISF and actually getting NAC canisters into Holtec CAF at the CISF, the NEPA review and alternatives analysis will have passed without our ability to be involved. On that point, I'll stop my opening statement and we can proceed to questions.
Thank you, Mrs. Izai. I have a couple of questions about your position. As I recall, well, I know Holtec opposed because Holtec opposed the standing of every petitioner. So Holtec opposed your standing, as did the NRC staff.
Yeah.
The NRC staff did not oppose the admissibility of contention 4, I believe.
Three. You only got the
three. Three. Okay.
Environmental. Basically, there's the two safety ones and one environmental.
Three is the one about alternative design.
Yeah.
Okay. And so one of them, both of them, perhaps, made the point that the UMAX CAS system is currently not approved for the NAC canisters, and Holtec is not requesting approval for that in this licensing proceeding. So explain to me again why NAC can't wait until Holtec does that.
Right.
Assuming it does sometime.
Right, assuming it doesn't sometime, but we don't have to do that because, and in regard, both on the standing ground, both Holtec and the NRC's responses are pretty much focused on this issue of we're too early, we have to wait. That's an argument we can get to with the safety contentions, and we can get that more detailed. But with the environmental contention, which is the one that the staff is not opposed to, does a favor there. The ER purpose and need statement says that we want to take spent nuclear fuel from plants all over the country. To do that, they have to take NAC canisters because NAC is storing spent fuel at power plants that are shut down and in operating facilities all over the country. That's not an opposed to point. Section 1.3 of the ER talks about how they're going to fit 10,000 canisters in the CSF, and they're evaluating impacts for 10,000 canisters. They can't get there with Holtec. They have to use NAC, and we can ask them about how they plan on doing that. So in order to do that, they have to provide an alternative, design alternative, that will accomplish that. So the proposed alternative, they run into this problem actually right now, because the proposed alternative is going to be using this Holtec system. They can only use Holtec system. That, by saying the Holtec system is not universal, they have no actual path to meeting their purpose and need statement at this point in time. But because of their purpose and need statement means they want to use NAC canisters, they're envisioning a universal system, and therefore our canisters will be involved. We can only participate on the NEPA grounds at this point in time. Let's say the proceeding ends, they move to phase 2. They're not going to evaluate the NEPA impacts of phase 2 or later on because they've evaluated here. They've already evaluated the impacts of the facility, and they've already said that we have a universal CAS system that can take any canister.
Now, Holtec says, I believe, I hope I'm not misquoting them, but, I mean, their position, the staff who filed simultaneously, of course, with Holtec, took the position that, yes, there was an inadequate analysis of design alternatives in the ER. Holtec's position is that you haven't made any showing that there are environmental consequences to design alternatives.
That's the materiality.
Pardon?
The materiality, right? The consequences.
The materiality, yeah. How speak to that.
Okay, sure. So they throw the NEPA book at us, right? You know, the rule of reason, it's not a research document. There's only 2 alternatives. But first, let's look at the legal standard. 72.34 says you have to have an environmental report. It ties back to 5145 says it's an alternatives analysis. NEPA regs on alternative analysis say that you have to have a reasonable basis or a description for why you decline to do an alternatives analysis. The new reg 1748, I believe, section 5.2.5 says the same thing. There's also section 5.2.4 that says you have to evaluate any and all reasonable alternatives. But particularly, if you're going to decline to do an alternatives analysis, you have to provide a reason why. Their reason, they disavowed. They said it's not a UMAX system. So for a contention of emission, we provided the basis for that. And so by having an incorrect basis to reject doing an alternatives analysis, you're not complying with NRC regulations because you haven't done the alternatives analysis. You're not complying with New Reg 1748, which gets, staff guiding gets due weight. You're not complying with NEPA regs. So you're having a material failure in compliance with NEPA. And you can't get a NEPA review certified. You can't get your license unless you've met all the requirements of NEPA. And honestly, it led to a decision, Florida Power and Light 75 NRC 615.
Is that in your petition?
No, I don't know if it's in our petition or not, but 75 NRC 615, which basically points out around page 625 that if you find a flaw that gets to being able to complete a part of your NEPA analysis, you have an admissible contention because you've raised a material issue with the adequacy of the NEPA document.
Okay. Let me ask a question for the staff. We could have a microphone over there. The staff's position was that NAC has no standing, has not established standing, but nonetheless, the staff agreed that, I may have the wrong number here, agreed that contention 3 would be admissible if they had standing. Now, have you had a chance to look at Holtec's response, which finds neither standing nor an admissible contention? And does that change the staff's view at all?
Sarah Kirkwood for the NRC staff. Yes, we have reviewed the applicant's pleading, and no, at this point, we are not revising our position on contention and admissibility.
Okay. So if in the hypothetical world you agreed they had standing, you would still say contention 3 is admissible?
Yes.
Okay, thank you.
If you want to head down this route, part of Holtec's answer gets to that there's no alternative that we should have analyzed. I would like to respond to that and say that, well, we did talk about an alternative. The alternative is what they wrote, using other cask vendors and canisters on the same ISIS fee. Now, remember, we're talking about design alternatives. We're not talking about designs for canisters or casks. We're talking about designs for an ISIS fee. There is a project being built down the road that lets multiple parties come in to work together to put their canisters and their casks on a broad ISIS fee. Every pad will be designed to allow for that to happen. Holtec was the cask and canister vendor in PFS. We cite the PFS in footnote 1. You can look at the EIS for that. They have to evaluate design alternatives. And also, you look at the SER, they only used their own cask and canisters. So that is, they're saying we don't have an alternative. They are the new alternative. They're coming up with this new approach to using a universal cask system, but they declined to analyze the standard approach based on the idea of just having a universal cask system alone, which now they've admitted it doesn't actually exist yet.
Judge Arnold, do you have any questions?
Yes, no questions on contentions, but I'm still stuck on standing. I look at the Holtec SAR 4.1.1 spent fuel canisters, and it says, the spent nuclear fuel bearing canisters that will be stored in the high store CIS facility are limited to those included in the high storm UMAX FSAR. No canister that is not included in the high storm UMAX FSAR can be stored in the high store CIS facility. Given that this seems to say explicitly that your canisters would not be used, how do you have standing?
There's 2 points I have standing. Let me deal with the environmental one, which I've been hitting on a little bit.
I don't believe our regulations differentiate between environmental standing and safety standing. It's just standing.
On the contention. So the contention has to be based on what gives us standing. Or at least let's go to the environmental report. So they make this claim that they're not considering NAC canisters at all. How do they get to evaluate the impacts then for storing spent nuclear fuel from all potlands across the country? How their ER's purpose and needs statement has to involve taking non-Holtec canisters. And that's what they get to in their design alternatives analysis. They say, look, how are we going to get here? How are we going to design the CIS that can do that? One way is to actually take everyone's canisters and casks and put them on our CIS. The other way is to do a universal UMAX, which they use the word universal there. So whenever they use the word universal in their application, they have to be relying on that idea of taking NAC canisters.
Well, wait. Do you infer that the word universal means more than, hey, they would fit in it?
The word universal means they will take canisters of any provenance. This is what the website says. Well, they'll take canisters of any provenance, whether these are Reva's canisters or NAC's canisters. That's what their website says.
So I'm interested in the application. Yeah. Websites are notoriously wrong.
Or if you want to claim Holtec's website is wrong, that's totally fine. But that gets to the definition. We're looking for guidance as to what universal means. And so if we have to figure out what the application says about universal, including the environmental report, which is part of the application, they're relying on a system that has to take NAC canisters. So I'm actually challenging Holtec's answer when they say that their application is not considering Holtec NAC canisters, because they're focused just on the licensing report part of it. They say that our application is only for phase 1, but they get to evaluate the impacts for all 20 phases one time right now during this application. So if they're going to evaluate all the impacts right now, they have to evaluate the impacts for storing canisters from every type of company, because that's what they're trying to do in the end. That's their purpose in NEAK statement: store spent nuclear fuel from all plants across the country.
So are you suggesting if this license is approved for only those canisters in the high storm UMAX FSAR, that sometime down the road, without a license amendment, they'll start putting NAC canisters in?
So, turning to the safety contentions of the safety report, they will possibly get a license amendment. They may not. We'll talk about that in a second. But one thing they will not do during that process is evaluate environmental impacts, because those impacts will already have been evaluated in this ER, because the ER says that we're evaluating all impacts during the 20 phases of the project, including the design of the CISF. They're finalizing the design for the CISF now in terms of a NEPA review, because they're analyzing all 20 phases of the project at once. So if they amend later down the road, so they can, add phase 2, add phase 3, and they get the approval to store radiologically that much material, they're not changing the design of the CISF, and they don't need to relook at the design of the CISF. They're only doing it once because they wouldn't want to do 20 NEPA reviews.
Now, I heard you suggest that...
And we can't analyze the design of the CISF later on. Sorry.
You suggested that a license amendment can happen without an environmental assessment?
A license amendment can happen without an environmental assessment if they've already done the environmental assessment. So, for example, with the nuclear power plant, you do a license renewal. There's a lot of environmental work that's already been done, a GEIS for license renewals. A lot of that's already incorporated in the regs. They don't have to analyze that again. So if they've done the environmental review for the design of the facility all at once now, they will just cite to that. They do not have to do, they're going to take the position they don't have to do an environmental review later. And I don't see any response to that argument. I'll get a chance tomorrow, I guess. And to the safety contentions in the licensing report. So our thing is, there's 3 concerns. And you asked, one of the questions was, why is a license amendment process worse than a license process? And we've dealt with that in the environmental report issue. There's 3 issues with waiting on the safety analysis part. One is 72.46 allows the NRC staff to grant a license amendment before allowing for a hearing. Now, we've looked at PFS the other time we've licensed one of these things. That was a massive hearing to discuss canister interactions. That would all happen, 10 years would pass, 5 years would pass, a very long period of time would pass. All that time, if the amendment is granted first, then Holtec can put NAC canisters in Holtec's casks. And we take all those risks that we were talking about, and we talked about in our contention. And then after that, the thing with spent fuel storage is it's hard to take out canisters from casks. When you don't want to do an unnecessary dose, there'll be issues with actually enforcing that process. So that's one thing. We would be very concerned about the issue of a pre-hearing amendment. Step 2. The second issue is the language. Now, we point out a reply, and we can deal with the motion to strike issue if you want to right now. But they have all these technical statements that talk about how they're having a universal capability, how their casks have been engineered to store materials, any canister. So those will stay in this SAR. That will become part of the licensing basis for the facility, and we will not have had a chance to object to those statements. What we don't want to see happen is down the road, they try to incorporate this license amendment, and they say, well, we've already discussed this in this SAR. The licensing basis says it supports statements that our cask is big enough or, technically sound enough to store any canister in cask, any canister within its cask. So how do we deal with those statements? This is a unique situation where we have an application that says different things. We have an application that says at one point we have a license condition to only take Holtec canisters right now. And then as part of the ER that says we're evaluating, we have a universal CAS system, and then all these other statements. So how do we get a chance to object to those? We've actually, we talked about this in our reply, but we think there would be 3 things we would need in order to have preserved all our rights. Some sort of, let me get to this here, actually, let me just quote it. No, statements in this application cannot be relied upon as a technical basis for approving insertion of a non-Holtec canister into a Holtec cask. We have to make sure we have pre-amendment hearing rights, and we have to make sure it's noticed in the Federal Register. The third point is, there are things like administrative license amendments. The 7216, the regs do say that they're supposed to notice any amendment, but every day licenses change RSOs, change phone numbers. This is a low-risk thing, but we are concerned that it could be determined that this is an administrative license amendment because the COC has been amended, and we don't get a right to a hearing. Note that the only reason we mention this is there's note in the answer. There's no statement actually by Holtec, I believe, and correct me if I'm wrong, that we get hearing rights. They say we get to participate at that point in time. We get to participate through a variety of ways that maybe have no legal bearing. So unless we're willing to say all those things are true, then we don't get the same rights in a license amendment proceeding as we get in a licensing hearing.
This NEPA analysis, which you're claiming is basically covers every other canister ad infinitum, what's the basis for your saying that that's what will happen if a license amendment is filed in the future with respect to incorporating NAC canisters into this license?
Remember, we're talking about then too the actual statement of the design alternatives analysis that relates to the fact that they're relying on a universal canister. Section 1.3 of the ER states that we're analyzing all 20 phases of the project. Section 2.2, I think, also gets into this as well. They're saying that this ER, there's other parts of this ER that say this ER is for the final design of the facility. So when they make that final design, they're designing to incorporate only UMAC casting canisters that have to meet the purpose and needs statement.
But your contention, too, is really saying that's inadequate. You need more information that you don't have to be able to claim universality.
No, contention 2 is the safety contention, right? We're talking about the omission, or are you talking about the NEPA contention?
Well, I'm asking, your contention 2 indicates there's technical information missing.
Yes.
Would that also apply to the environmental report, the NEPA analysis?
So,
could they say we have universality and whatever information they have is adequate? Is that what you're saying, or are you saying you can't make that universality claim because you don't have certain technical information from us?
So on the safety
contention. On the environmental side now. On the safety side, there's no question in my mind that any license amendment would have to reevaluate the safety side. Is that not correct?
On the safety side, yes. We would want to believe that a license amendment would open the door to reevaluating the safety issues.
Right.
And if they say that they don't, and they're going to rely on any part of this application for a later license amendment, then they're not. Then they're actually doing the opposite. Then they're saying they're not reevaluating safety issues in a license amendment proceeding. And that's the concern we have, and we just talked about with relying, for example, on some of those assertions or statements made in the licensing report later on to avoid doing additional safety analysis. With the environmental review, sorry, you were going to say?
No, go ahead.
With the environmental review, I think this gets to the question, and correct me if I'm wrong, about proprietary information. One of the questions in the list was, do you need proprietary information to do an alternatives analysis? The proprietary information is needed for their alternative, for the proposed alternative. It's needed for them to be able to fit non-Holtec canisters into a Holtec cask. To evaluate alternatives, you don't need any proprietary information at all. And it's a business. I make light of this, but it is a business that you can hire people to do analyses for NEPA. That's the whole industry. And when you look at, for example, they cited the Vogel ESP, so I just picked this one up, in page 19 or 20. If you look at the EIS for Vogel, they had to compare the nuclear power plant for the expansion against natural gas plants, against coal plants. They didn't have to call up Massey Coal and ask for proprietary information to do that analysis. Now, they can go as far as is reasonable. Instead of relying on this universal cap that they've now said doesn't exist, instead, what if they had said the alternative analysis? We looked at it this far, and this is what we could come up with based on our analysis. That might be going as far as is necessary, but they haven't done that. And they can't just assert near the end of their answer that proprietary information might be needed to evaluate alternatives. They have to actually do that as part of the NEPA process. Otherwise, they're getting a chance to rehabilitate their ER through the answer, which doesn't satisfy the requirements of NEPA.
And if a license amendment is requested in the future, this contention you're filing now would not be valid?
The environmental contention would not be valid because if they filed a license amendment request in the future and we said you should evaluate an alternative design to the CISF, they would say, wait, we evaluated the design of the CISF right now, all 20 phases in this ER, which then becomes an EIS. And so we've already evaluated it. You're out of time. This is the bind we're into with this misleading marketing, too. We have to be present at every phase to avoid that from happening. And the ER is a very prescient risk because they've already said that they're evaluating all 20 phases of this project now.
And what you're looking for is for Holtec to work with you in the same manner as the interim storage partners?
We're just looking for contention admissibility. We're looking to make, a broader scope, and we can get to
what's the end? Whenever you have a contention admitted, you're looking for some judgment. Yeah. I don't understand what it is that you're looking for.
We got contention admitted, pointing out a material flaw in the NEPA analysis. We have a hearing to determine the scope of that material flaw, the correction to the material flaw, and to make sure we get our voice heard as to the extent they're going to rely on a universal CAS system. So they're saying they're going to rely on a universal CAS system. That's kind of the foundation of what we're opposed to, because a universal CAS system is going to use NAC canisters. If they're going to rely on that universal CAS system, we should get a contention in that allows us to go to a hearing and really evaluate whether that universal CAS system can be relied upon for the ER. This is the only chance we're going to get to do that. And the part of that might involve evaluating alternative analyses, but that's for the hearing. And to get the contention in, we just have to show that they had a material flaw with meeting the requirements of NEPA, and failing to meet 40 CFR 1502.14a, which is the requirement that you provide a basis for rejecting to do design alternatives, is a material flaw with NEPA.
Does the staff agree with your reading of all this?
Well, staff did not object to our contention admissibility. They agreed that we pointed out something that was incorrect in the ER. They agreed that we can get a contention on that, so we would get the hearing to evaluate that statement.
Right. With respect to loss of NEPA rights?
With respect to, yes, the NEPA issue.
Staff agrees with your reading that NEPA rights will be lost in the future.
The staff does not agree to standing, and one of the arguments they make is that the CISF, or it's basically the same argument Holtec has made, which is that we're not contemplating a universal CISF at this point. To which our response is, they are for the ER part of this at the very least. And for the safety, we have this argument about all the statements they make in their application. But particularly with the ER, it's a much simpler point. They are contemplating universal CISF because they have to, because their ERs for the final design of the facility.
key for me is why there would not necessarily be an ER amendment in if a license amendment is filed.
So the license amendment, let's see what that would cover. The license amendment would say that the license amendment is to incorporate a COC. The COC would say, or the amendment to the COC, that would say we can fit a canister of Areva NAC into UMass CAS. That is the basis of this amendment. And so we'd be able to challenge whether that's accurate on the safety ground, whether that might result in some other impact. But the alternative design of the facility will have already been set, because this ER is 20 phases long. It's just setting the design for the facility. So later, if we have an amendment proceeding to deal with this COC amendment, we'll get to talk about the NEPA issues related to that COC amendment, but we won't get to talk about the alternative design of the facility. And you'll tell us, too, that we should have done that when the design of the facility was actually up for bat, which is at this point in time.
It seems to me that what I'm hearing you say in part is that you're here today because if you're not here today, you won't be heard tomorrow. And on that issue, plus generally this contention or this petition, I'd be very much interested in Holtec's response, which Mr. Silberg, at your option, you could address now or tomorrow when we get to you. Which do you prefer?
If you could restate the question, and then let me...
I mean, what I'm hearing a lot here is that NAC is in this proceeding today because they're concerned about events that may or may be likely to happen in the future, and that they will be prejudiced in their ability to deal with those events in the future if they aren't here today filing this contention. Is that, Mr. Desai, is that a somewhat accurate statement?
On the environmental side.
On the environmental side.
And I would add to that we are responding to, in essence, their counter, right? We've said in our petition, this is, they're licensing and dealing with the environmental impacts for universal CISF now. They're responding and saying, no, it's not a universal CISF right now. To which our response is, they're dealing with these universal CISF issues now.
Okay. So. And Mr. Silberg, do you want to respond to that now or tomorrow?
Tomorrow. I think the answer is, we think that's incorrect, but we'll have a fulsome answer.
Okay. Well, we'll make a point of asking you that tomorrow. Shall we continue with that, or break? For 10 minutes? Or for 10 minutes? Shall we just stop today? Yeah. I think rather than begin with Fasken with only less than 10 minutes left, we will call it a day today. We'll begin at 9 a.m. tomorrow. Thank you, Mr. Desai. We'll begin at 9 a.m. tomorrow with either the representative from the city of Carlsbad or Fasken, Mr. I. And then we will get to Holtec and the staff. And I think I think there's a good chance we will finish by lunchtime. We will see how many questions we have for you. So that is it for today. We'll see you all tomorrow. Thank you.